Welcome to Series 3 of the HIP Talks podcast, a series of discussions on legal issues hosted by Hugel and Ip solicitors. The firm provides high-quality legal services with integrity, professionalism, and respect for its clients and the community. An outstanding team of lawyers who have achieved exceptional results and recognition in the areas of dispute resolution, corporate and commercial, private client, family, employment, business immigration, and data privacy.
Good morning, listeners. I'm Geraint Ho, and today I'm here with Alfred Ip. We are from Hugel and Ip, and today we are here to talk about inheritance disputes, specifically how to challenge a will in Hong Kong. Hi, Alfred.
Hello, Geraint.
Good to see you. Well, first things first, Alfred, can I ask what it means to challenge a will in the context of a legal dispute? Does it mean to have the will declared invalid or something else?
A lot of time is about declaring a will invalid, but another time is just to put a will to strict proof. That is, to ask to the testator to prove that the will is valid properly.
Right. Well, from what I understand, normally in the probate process, when a person passes away, the executor of a will would have to go through a process of proving the will with the local authorities anyway. So could you perhaps expand a bit more on what you mean when you say putting the will to strict proof?
So nowadays, when a testator passed away, the executor named in the will has the responsibility to prove to the court that this is the last will. And in the course of the application, if there's nobody who comes forward to challenge the will, the court would accept that the will is valid and enforceable so long as it appears to be one. The common requirement for making a will is that first of all, it has to be in writing, and then it has to be signed by the testator with the two witnesses. If a document purporting to be a will contains this kind of element, the court will usually accept it. But that is important. If someone believes that a will is not valid and they want to challenge it, they have to take action fast, because once the will is probated, it will be much more difficult for anyone to seek to challenge it, especially when the will is probated and the assets of the deceased has already been administered. Where are they going to find the assets and try to set aside the will? What's the point then?
Right. So it seems like speed is of the essence in terms of wanting to challenge a will, and someone has to bring a challenge before the estate gets distributed away.
Yes, correct. And the first thing that we will ask our client to do is to file a caveat. Geraint, do you know what is a caveat?
No, not really.
Okay, caveat is effectively a notice to the court not to issue a grant to anyone without the person who issued the caveat notice. We call that person caveator. Caveator has the right in the estate, and those who want to probate a will has to clear that caveat before a grant of probate will be issued to him. So the first thing that the caveator would know is when a person asks to probate a will, they will issue a warning. Warning is a piece of document. It sounds like, it is a warning, but actually it is just a piece of document. The purpose of it is to ask the caveator to explain what contrary interest he has in the estate. And after receiving the warning, the caveator can file a document called appearance. Otherwise, the caveat would not have effect after 8 days of the receipt of the warning. And if the caveator issued an appearance, the appearance will state what sort of contrary interest that he has in the estate. And after filing the caveat and warning and appearance, the parties would start this called caveat proceedings. There are two ways to go about it. Either the caveator or the person warning would issue a probate action. That would be the commencement of a probate action. Or they would continue with the proceedings in the caveat proceedings, seeking various relief that they would be advised to seek from court, and the court would decide upon that.
Thank you, Alfred. That's a very detailed summary of the procedure. Now, I've heard the term contrary interest being mentioned a couple of times. Would that be something like saying I have another will in my hands and what you are trying to probate or prove to the court is not in fact the correct will of the deceased, would that be something that's a contrary interest, or are there anything else that could be classified as a contrary interest?
That could be one of them. And another situation would be when a person is supposed to be the administrator according to the intestacy rules, and they realize that actually there is a will that they didn't know about, and somebody else is entitled to grant instead of them. And they want to inquire as to who the other person is and why they are entitled to administration. And that would be a question to be decided by the court, and probably that person would want the executor to prove to the court that he is indeed entitled to administer the estate by proving that the will that he has in hand is valid. And the other person may want to challenge the will.
Right, so it sounds like we are sort of moving the topic into how we actually sort of bring legal proceedings or sort of fight the case in court. Now, putting myself in the position of someone who wants to bring a challenge to a will, could you sort of take us through what sort of grounds people usually rely on if they need to challenge a will?
Well, it very much depends on the circumstances, but most of the grievances that we heard from the family member is that they were not aware that the deceased made the will. And after knowing more about how the will came about, they have a lot of grievances towards that process because they're not involved. Naturally, they will have a lot of questions. And these kind of questions usually surrounding these kind of circumstances. First of all, was the will properly executed? And for a will to be properly executed, there are a few elements to it. First of all, the testator should understand the contents of the will and its legal effect. So, it should be properly explained to the testator what is it in the will. Sometimes, the person who signed a piece of document didn't really see it before signing it. And in the context of a will, this is a big no-no because will is a very important document. The major effect of it is that it only takes effect after the person passed away. And the person who signed it usually cannot come back and explain that, I did sign the will and that I understand the legal contents of it. And this is the reason why the will must be properly executed. And the process of execution should be properly documented. And this is the reason why we always advise our client to make the will before two lawyers or two legal professionals who understand and have experience in attesting a will. And apart from due execution, of course, there are other problems that may surround the execution or the drafting of the will, such as, was the person who signed the will had mental capacity? Mental capacity is often an issue, especially when the will was made at the deathbed or after the person discovered that he has some illness, serious illness, or life-threatening illness. This is particularly the case when the will was signed in the hospital, when the person who was making the will was already subject to various medical treatment, and the medicine may compromise their consciousness or their mental capacity. Sometimes, when the person is subject to the medication, they can be better, they can be worse, and sometimes they are seems to be functioning normally, but at the other time they just sleep. There's a lot of time when the family comes to us and say, it's never possible for the person who passed away to make the will on his deathbed when I saw him all the time and she was always very sick. But that doesn't mean that the person who signed the will did not have the mental capacity at that time. Because even sometimes when the person is in deathbed and he cannot speak, all he has to do is to move his finger and indicate that he understands the instructions. We come across cases when the lawyer was asking the patient, you understand what I mean? If you understand, tap 1. If you do not, tap 2. And the patient would tap 1. And then he asked further question, do you understand that you are making a will? He tapped once. And then, do you understand the contents of it? He tapped once. So all this should be documented, but it doesn't mean that the person indeed had mental capacity. He may just tap. So it very much depends on the circumstances when we are talking about testamentary capacity. But the golden rule is that when the person is about to die, or is an age that is so old that it's always safe to have a doctor attesting the will and confirming the mental capacity of the patient before he signed the will. And of course, there are other grounds such as knowledge and approval, fraud and through influence, forgery, or revocation. All these are potential grounds that we can discuss later when doing this podcast.
Right. It sounds like there are some very complex factual matters that have to be taken into account when somebody wants to challenge a will. Does that mean that these sort of challenges are usually very difficult to succeed in court? And what are sort of some of the main hurdles?
Yes. I can share with you some of the experience that we had. The major hurdle that a lot of clients face is that he or she was not there when the deceased made the will. For example, he did not know the will come about after the person passed away. He didn't know who basically orchestrated the whole making of the will. That would be difficult to show that the person who arranged the whole will to be made, indeed exerting such a fraud or undue influence that believe he had. For example, a carer who has been looking after an elderly in the last years of his life, and after he passed away, suddenly the family member discovered that there's a will. And the carer apparently is the only beneficiary under the will. That means that the family members are totally disinherited. Of course, the family members will have doubt, and they will wonder why would the deceased leave everything to the carer. And of course, the carer may come about and say, the deceased complained to me that the family members ignored him and he didn't look after him, didn't pay attention to him. The deceased was very dissatisfied or very disappointed about the family members, and they only come about when after he passed away, and only going for his money. This is a very typical or soap-opera-ish legal dispute, and it would be up to the family members to show that actually the carer, in the course of taking care of the elderly, he or she did do something to make the elderly making the decision. She could be brainwashing or keep infusing the mind of, your family members is not looking after you. Why are they? What are they doing now? Why are they not coming to see you? And things like that. It may or may not be undue influence. But what is it for the family members to show that the carer did say these things to the elderly? Because, of course, he or she wasn't there when the carer says these kind of things to him. So this is the difficulty that a lot of people face when they are challenging the will. But of course, the court do understand this, and it would be up to the person who try to prove the will to show that the will is properly executed and is valid and legal. And this is what we call to prove the will in solemn form. And that is the reason why a lot of people do not understand what is it the evidential burden to prove a will. But of course, it doesn't mean that it is not difficult to challenge a will, because at the end of the day, a will is a legal document, especially when it is drafted and attested by legal professionals who have experience in attesting the will, because he or she should know what it is like to make a will valid.
Mm-hmm. And it sounds like a lot of the main hurdles or difficulties from a potential claimant is to actually gather the evidence in relation to this potential challenge. So if I'm a potential claimant, is there anything I can do to sort of build up evidence to strengthen my case? Because, as a lawyer, my understanding is that the strength of your case is very much dependent on the strength of your evidence.
Yes, and the first thing is to carry out investigation. Carrying out investigation involves such as seeking a copy of the will and, if necessary, seeking the underlying documents pertaining to the will. A lot of people do not understand that apart from the will, there might be other documents that indicate the deceased wishes. And in that respect, we have come across cases when, for example, the lawyer's note, the note that was taken by the lawyers at the time when they're taking instructions and preparing the will, or other documents such as some deceased handwriting. We have come across a case that an elderly actually written what he or she wanted before making the will and handed it to the lawyer before the lawyer drafted the will for him. And without knowing all this evidence, it is difficult to assess how likely is it that a will can be challenged and whether the will reflects the wishes of the deceased. And this is the reason why sometimes it is difficult to gather all these documents. And the lawyer's role is to help the client gathering all this by asking the right question.
Right, and you've mentioned about how someone can obtain documents from the lawyer who was involved in preparing the will. Now, if I was that lawyer who prepared the will, my first reaction when I receive a request for disclosure of documents would be that I owe the duty of confidentiality to my client. As a claimant, is there any way I can get around this when the solicitor says, I have a duty of confidentiality?
Well, don't forget, duty of confidentiality is towards the client. Who is the client? The deceased in the context of a will. And after the deceased passed away, whether there's this duty of confidentiality, and if there is, who's this duty owed to? From the lawyer who drafted the will, to whom that duty is owed to. If there's any doubt as to whether he or she disclose the document to the person requesting it, the answer is that in Hong Kong, there's cases that can be followed, and it is up to the court to decide whether such disclosure should be ordered. And the person who is holding this information should assess whether it's likely for the court to order this information to be disclosed. I would say that the lawyer who drafts the will should be careful into entertaining this kind of requests from any person who seeks this kind of information.
Right, so that does sound like an extra layer of complexity if we have to bring this sort of application or investigation. So does that mean that challenging a will can potentially turn out into a very lengthy and drawn-out legal battle that would take years and years to be resolved?
Yes, indeed. Just like any other civil litigation, it takes years for a dispute to be resolved through legal process. So we always advise clients the desirability to resolve this kind of dispute through other means, such as mediation or even private dispute resolution.
Right, and how often is it that parties end up settling a case and not letting it go all the way?
Actually, according to our experience, more than 90% of the cases settled or resolved one way or another without going through the whole trial.
Oh, that's good to hear. But at the same time, I can also think of a potentially unfortunate consequence if parties decide to have to go all the way and spend years on this. Now, I'm going to pose a situation to you. If, for example, I am the widow of the testator in question, and, for example, I've just been a housewife all my life, and I've not been working, I've only been getting a monthly allowance from my husband for my expenses and spending money for groceries and so on and so forth. And now I'm getting caught up in this lawsuit with regards to challenging my husband's will. Does that mean that I'm not getting any allowances for years while this case plays out in court because I've all along been getting money from my husband and his estate is now locked up because of this court battle?
Well, it then very much depends on how the will was drafted. If the will was drafted is that you are disinherited from the will for one reason or another, then the first thing that perhaps we will advise you to do is, instead of challenging the will, to launch another proceedings under Inheritance Provision for Family and Dependents Ordinance, that is Cap 481, to seek your right of your entitlement under the estate. And it is a little bit shorter in terms of process, because in the proceedings we can ask for interim provision from the estate to look after your financial needs in the interim. So there are many ways to bring about challenging a will or an estate. It is important to be properly advised and have different strategy when you're dealing with a situation.
Right. And I'm also thinking of another situation now where if a testator has liabilities right before he passed away, would his creditors have any relief in terms of getting their debts paid in the interim?
Absolutely. The first thing that they need to do is to secure their interest in the estate. That is, the liability will be repaid before any distribution is made to the beneficiaries. So the creditor should ask the executor or the administrator to make an undertaking to them to pay all the liabilities. And in that respect, the first thing again is to file a caveat in order to identify the person who is going to administer the estate. And once the person is identified, seek an undertaking from him or her in order to secure the interest. And in that respect, I want to add is that after a person passed away, the administrator or the executor has an responsibility to administer the estate. And after calling in all the assets of the deceased, the first thing that comes out is the testamentary expenses and the funeral expenses, and then it's the tax, and then it's to be paid to the creditors, the secured creditors and the unsecured creditor. After all these are paid, the beneficiaries will only be entitled to the estate if there's anything left.
Right, that's a very comprehensive explanation. I just want to step back a little bit because you mentioned that the widow can bring a claim under the IPFDO. Could you take us through a little bit about that?
Yes, actually, widow is only one of the 9 categories under that ordinance who is entitled to bring a claim. But then there are only a few categories of people who can bring a claim without showing that he or she has been a dependent. That is the spouse and the minor children, because they are expected to be the dependent in the estate. And in order to bring a claim against the estate, they don't need to show that they have been receiving financial support from the deceased. Otherwise, any other person in other categories have to show that they have been financially maintained by the deceased. And these categories of people involve adult children, other relatives, or any other person who has been financially maintained. In that case, that means that basically anyone who has been receiving money from the deceased during his lifetime can bring a claim. It's very wide, but of course the evidential burden is also very high. They literally have to show his or her relationship with the deceased and the fact that he or she has been receiving maintenance from the deceased during the lifetime. And after the deceased passed away, they have financial difficulties, that such financial maintenance should continue.
Right. Now, Alfred, you mentioned that anybody who is a dependent who can prove that they're a dependent can get a claim out of this ordinance. Well, forgive me for saying this, but from a moral perspective, would it be fair for the estate to actually have to pay out to somebody who isn't part of the deceased's family?
Well, it very much depends on the circumstances, but think about it. If a person who has been receiving financial support from another person, and that financial support suddenly ceased, and that person becomes despondent, he or she doesn't know how to live, and Hong Kong is a very expensive place, it's actually very important to offer that dependent some sort of protection in order for him or her to carry out her life. How much should he or she receive is a matter for the court to decide. But he or she should at least have some sort of financial relief so that he can carry on his life.
A very interesting take, Alfred, and that does make sense. So stepping back a little bit into the court proceedings, if a court at the end of the day has to make a decision on the will, what sort of outcomes are there usually?
Well, the court would either rule that the will is valid or invalid.
So that's a very straightforward yes-no type of answer.
In a way, it is, but of course, it may not be entirely black and white. The court is under the power to order that a particular clause is not valid or interpret the will in a way in order to carry out the testator's wishes.
Right. And also another situation, if I'm a claimant, I'm challenging a will, and my reason for this is because I do not think this will in question is the valid one, and I want to prove another will. Can I do that in the same proceedings? And does that turn into a sort of contest as to whose will is the valid one?
Yes, of course. But of course, it becomes more complicated because not only you have to show that the other will is invalid, but also you have to show that the other will is valid. So it's like double the effort.
Right. So it seems as though the burden of proof now goes back to me trying to prove my version or my will.
Correct. And that's exactly the situation when the court has to deal with the will of Nina Wang. If you remember, Tony Chen came forward and tried to prove that the will leaving everything to him is a valid one. China Chem Foundation seek to disprove the will of Tony Chen and prove that the will leaving everything to the charity is indeed the will that is valid. And at the end, China Chem Foundation won. But then later on, the court decided that DOJ comes in and interpreted the will that China Chem Foundation is indeed the trustee, not a beneficiary. This is probably the most influential case in Hong Kong in the past years, especially with someone that is so legendary.
Well, interesting that you mentioned a very high-profile case just now, Alfred, because I think we all want to avoid long and high-profile legal battles like what Nina Wang had to go through.
Yes, indeed. Especially when she was trying to prove her husband's will and went into a years-long legal battle with her own father-in-law and then made the will that is subject to challenge.
Right, and speaking of going to a legal battle with your own family members, wasn't there a case about Anita Mui and the estate of Anita Mui and her mother?
Yes, the mother is seeking to challenge the will that she made during her deathbed. And it is a very sad case because the mother claims that the provision given to her was not enough to provide for her with her, can be described as lavishing lifestyle. It is very sad, and this is the importance of communicating your wishes to the family members in order to avoid this kind of dispute from happening in future.
That's a very good point, Alfred. And I know you might have mentioned some of this before, but could you just sort of recap some take-home points for us as to how we should do our estate planning or how we should have our wills prepared to avoid this kind of disputes?
Well, first of all, it's important to have the will properly made. And don't wait until you realize that you're about to pass away to make a will, because there's often an extra layer of complication. And secondly, seek professional advice. A lot of people have the misconception that making a will is very easy, and they want to avoid spending money on it. But the money that you spend on making a will properly can save a substantial amount of money for people challenging the will in future. All you have to do is to get it properly done. And if it is such an important decision, involve your family. Explain to your family why you have such decision, so that your family can come to make peace with it. I think it's very important for the family members to hear it from yourself, what you want to do with your estate and why you want to do it. And if the family members have any problem, voice it out when you're still alive, so that they won't have to fight over your estate after you passed away is literally leaving a big problem for your family members to deal with. That is not a show of love.
Thank you, Alfred. That's very sensible advice.
Tune in and listen to more episodes of the Hip Talks podcast by checking the Insights section at our website at www.hugelandip.com and our channels on Apple Podcasts, Spotify, Google Podcast and Stitcher. They are also available on Hugel and Ip's YouTube channel. You can send comments and feedback to our email address, hello@hugelandip.com. If you found the Hip Talks interesting, please share them with friends, family and business associates. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.